An officer should respect your right to legally carry. But what happens if an officer finds out you are carrying, he gets antsy, and now he draws down on you? What happens when in that split second, you're frozen, your heart's pounding, and you have to decide what to say and what to do before you make your next move? In 2025, the United States Supreme Court changed all the rules. They've made it crystal clear. Everything you do before the officer draws down on you can decide whether you walk away free or not at all. I'm Jeff Hampton, and in today's video, I'm going to cover the 5 factors every gun owner must know before an officer gets aggressive with them, so that you can both survive the stop, protect your rights, and know what to say and not to say so that your behavior becomes evidence that helps you and not something the cop can use against you. But before we break down these 5 factors, you need to understand why this is so important right now. For decades, courts have judged police shootings by only looking at one little slice of the encounter. It's known as when the moment the trigger was pulled. In fact, the courts ended up referring to it as the moment of threat rule. If the officer could say, "I felt endangered," that was it. They didn't have to answer for any decisions or actions that led up to that moment. That's like letting a quarterback throw an interception, but only grading him on the last step before the throw. Everything else, the bad reads, the missed blocks, completely ignored. All of this ended in 2025 in the United States Supreme Court case known as Barnes versus Felix. Here's what happened. A constable in Texas pulled over a man by the name of Ashton Barnes for unpaid tolls, a minor violation. During the stop, Barnes actually decided to drive away. The constable, Deputy Felix, jumped onto the hood of Barnes's car, and as it was moving, he fired shots into the windshield, and ultimately it ended Barnes's life. Now here's what's important. Before this case made it to the Supreme Court, the Fifth Circuit Court of Appeals said that they were only going to analyze this at the moment the shots were fired and ignore everything else leading up to the shots. This is critical because they ignored the fact that Deputy Felix put himself in harm's way by jumping onto the moving car from the very beginning. Thankfully, the United States Supreme Court, under a unanimous court opinion written by Justice Kagan, said no, that's not how this is going to work. To decide now if police force is reasonable, you must consider all the circumstances, including everything that leads up to the point where shots were fired or force was used. So you might say, okay, Jeff, what does this have to do with me as a concealed carrier or a gun owner? It means that you, as a gun owner, must now know these 5 factors inside and out if you find yourself in a situation where police start getting aggressive or antsy with you. By knowing these 5 factors, you will be able to make sure that your behavior, your words, and all your actions protect you as opposed to jeopardizing you in a police encounter. The best news? This puts you in control. If you know which factors the courts are going to weigh, you are going to be able to make sure those factors turn in your favor and not the police. Factor number 1, severity of the offense. Here's the plain truth. The more serious the crime the cop thinks you have committed, the more they are able to justify using force against you. For example, if an officer believes you fit the description of a violent felon, particularly one he thinks is armed, get ready, that officer is going to draw down on you, and you should expect it when he approaches you. You say, that doesn't seem fair. I didn't do anything wrong. There's supposed to be a presumption of innocence. Even if you're not that guy and you've done nothing wrong, you've got to be prepared to respond appropriately. And here's why. Back in 1995, the U.S. Supreme Court decided the case, very important case, of Tennessee versus Garner. In that case, police shot and ended the life of an unarmed teenager suspected of burglary, a non-violent offense. The court said no, this is not allowed. In fact, this is the exact wording they used. They said, the Fourth Amendment forbids deadly force against a fleeing suspect unless they pose a significant threat of death or serious physical harm. In plain English, deadly force is never reasonable just to stop someone from a minor offense. Now that's been the law for decades, but let's fast forward now to 2025 and the Barnes case and why exactly this is important to you. Remember, under Barnes, courts are not allowed to look at only the instant that shots were fired. Courts must now examine what did the officer actually know about the severity of the offense at the moment he used the force. Now remember, in Barnes, Deputy Felix pulled over Barnes for unpaid tolls. That's not armed robbery, that's not aggravated assault, but yet this escalated to use of deadly force. Post Barnes, and this is really important, If the underlying offense that the officer escalated to use deadly force on was minor, it can be used against him. This is critical. This makes a big difference when we're talking about things like qualified immunity, when we're talking about federal civil rights lawsuits. We can now analyze not just what happened at the moment shots were fired, but we need to know what did the officer know at the time he chose to use this deadly force? What did he know about the severity of the alleged crime? So what does this mean for you as an armed citizen? First, you can't control what crime cops think you might have committed. There's misidentifications all the time. There's officers that only go off of a hunch as opposed to actual evidence. But you can control how you choose to respond in that moment. If it's a basic stop and cops start questioning you about a minor offense, don't give any reason for them to escalate it. No sudden movements, no aggressive tones. And remember, the big difference here is you're carrying a gun. If you are legally carrying, it puts you in a different position and a different risk when an officer tries to start escalating the encounter. If you live in a duty to disclose state, you can choose to inform them right away, so you don't want them to find out about it by surprise. But it's important to understand, don't overreact just because a police officer is alleging you've done something you know you didn't do. For example, if you live in a duty to disclose state, here's one of the things that you could say. You could say, quote, "Officer, I want you to know I am licensed in carrying. My firearm is on my right hip. My hands are going to stay right here on the steering wheel." If you are detained as a suspect for a serious crime and you've done nothing wrong, don't panic. Let the officer confiscate the gun. He's going to do that just as he's allowed to do under protocol. But you also want to be able to make sure you don't do anything to escalate the encounter. Remember, when you are armed and an officer gets out of control, the number one goal is to survive the encounter. And then if he takes it too far after that, under these new post-Barnes rules, we can now essentially look at everything that was done leading up to the use of force, and now that can be used against the officer. Now I'm going to stop and answer this quick question. I have a lot of people ask me, well, Jeff, how is this fair? The officer could just be making it up, claiming he thinks I'm a suspect in something. That's not what the court said. The court says the officer must have reasonably believed that you were a suspect in a crime. And so him just having a hunch or just trying to use it to give you a hard time, that once again could be used as one of those factors to consider here before the officer used force against you. So remember, if the officer's out of control, your behavior will affect what he's allowed to do even when he was wrong. That's why the body cam, the dash cam, and even your witnesses on scene become your best friend. So what do we learn here from factor number one? Stay calm, don't panic, but exercise your rights. Your job, when a police officer takes it too far and starts to use the use of force against you, starts to actually try to be aggressive with you, your job is to survive the encounter and then use that officer's unreasonable behavior against them in court. But even a minor offense can go bad fast if the officer believes you're an immediate threat. That brings us to factor number two. Factor two is one of the most important in any use of force review, and that is, did you pose a quote, immediate threat? Here's the standard. Under the law, if an officer reasonably believes you pose an imminent threat of death or serious harm to them or others, they can respond with deadly force. And here's the kicker. Courts have been very forgiving to police officers when the entire encounter is fast moving and things are taking place, and courts even think there might be a chance that person was a threat. In Graham versus Connor, the Supreme Court made immediacy of threat one of the key pillars in determining whether objectively a police officer's use of force was reasonable. Then, in Casella versus Hughes in 2018, police officers confronted a woman who was holding a knife. Within seconds, the officer shot that woman he thought might be holding a knife because he claimed he thought she might be a threat to someone else nearby. The court didn't rule on whether the shooting was right or wrong, but they did grant the officer qualified immunity for, quote, the situation was tense, uncertain, and rapidly evolving. Translation, if cops think that you're going for a weapon, they can fire and courts will back them up. So for you as a gun owner, the mission is clear. Don't give any reason for that police officer, particularly during a traffic stop, to interpret you as being an immediate threat, particularly once the officer knows you have a weapon. That means no sudden movements, no what cops call furtive movements, no reaching into areas where cops can't see, no taking your hands from the steering wheel and reaching down under the seat, None of that. And one of the most dangerous things you can do is to reach for your glove box, to reach over to your center console to pull something out. Cops can interpret that as you posing an immediate threat. So what do you do instead? You verbalize every movement you make. Get the officer's yes before you move to do anything, and always move very slow and deliberate. And remember, everything you say and do is now part of the record under Barnes. So if the officer starts getting aggressive with you, your reasonable movements, your reasonable behavior with that police officer will now be taken into consideration. For example, if later in court, an officer were to get up there and testify and claim, well, I did this and I drew down on him and I threw him to the ground and he was injured. I only did that because I thought he was actually trying to reach for a gun. If that's the case, but yet we see a body camera, we see your dash camera, we see witnesses, we see all of this now showing you asking very deliberately and moving slow, officer, because I'm in a duty to disclose state, I want you to know that I have my firearm on my hip. I need to reach for my license. Can I get your permission to do so? It's in my back pocket. Or I need to reach for my proof of insurance or registration. It's over here in the glove box. By you being very deliberate in explaining those things, it's going to cut against that officer and it's going to put things in your favor. Another pro tip here, keep your lap and your dashboard clear. Make sure there's nothing that's immediately visible to the officer that he could mistake for being a weapon that you might reach for. This is especially important if you're driving at night, because if a police officer's walking up and he already can't see very much in your car, and it's nighttime and he's shining a flashlight in your car and he sees something that he's mistaken for, I've seen officers immediately draw down because they don't know what they saw because there was something else that was either on the dashboard or in that individual's lap. You want the officer to only see your hands on the steering wheel and nothing else. You might be thinking, Jeff, come on, man. Are you just dramatizing this? It's not that big of a deal. I've literally seen multiple cases and dash cam footage on both of these where officers have drawn down on a driver and all the driver was doing was reaching in his back pocket to grab his wallet so he could pull out his license. And all of a sudden the officer yells, gun, gun, and he starts to draw down, and now we have a very tragic situation. That's why you must first pause, think about what's going on, speak to the officer about what you're going to do first, then move. So what have we done here? You've kept your hands visible. You've narrated your actions to the police officer, and you're not going to be considered a perceived threat. But if you don't avoid this next mistake, it can turn a bad traffic stop into a deadly one. Factor number 3 is very simple, but it's the one I see people blow the most when they get nervous and freaked out when cops get aggressive. If you ever resist an officer or run away from an officer, evade his arrest, the attempt to arrest you, you have now given that police officer one of the biggest legal justifications that exist under the law to use force against you, including deadly force. In Plumhoff versus Rickard in 2014, a driver fled from a traffic stop and hit speeds of nearly 100 miles per hour. Officers fired multiple times at the vehicle, ultimately ending the life of both the driver and the passengers. Amazingly, the Supreme Court said it did not violate their constitutional rights. Why? Because the flight created a grave risk to the public. In plain English, if you ever run, you've now turned the entire situation into a dangerous situation, and now cops can use it to justify doing almost anything they want. The same thing happened in Scott versus Harris. In this case, the driver was actually driving at high speeds trying to evade the police, and the officers used what's known as a PIT maneuver. Basically, they caused that driver to spin out and stop their car. But in the process of doing that, it actually took the life of the driver. But the Supreme Court ruled in favor of the police. But let's stop for a second and let's go back to Barnes. And this is where Barnes comes back in. Remember, Barnes wasn't an armed robbery suspect. He was only stopped for unpaid tolls, but he did try to flee the scene. And in reviewing that case, the Supreme Court said you have to look at all the facts involved here, not just at the time of the use of force. And so the first thing we looked at is, yes, it's a minor traffic offense. But secondly, did the driver attempt to flee the scene? Yes, he did. But thirdly, the officer also put himself in an immediate threat by getting on the car. For you, as an armed citizen, this comes down to one rule, and I hope this might sound like common sense, but in the heat of the moment, sometimes people make irrational decisions. You know, comply, don't fly. I know that sounds goofy, sounds kind of kind of tricky here to say that. But whatever you do, if the officer, even if you've done nothing wrong, if you try to flee the scene when an officer is accusing you of something, the moment you take off, you are immediately placing your life at risk. You know the old saying, you can beat the rap, but you cannot beat the ride. Even if the arrest is completely wrongful, your best odds are to win in court and not try to flee the scene and avoid the police. This is especially true if the officer tries to disarm you. Every police department has different policies, but the worst thing you could possibly do is if the officer reaches in and tries to start to disarm you and take your weapon from you, don't turn it into a tug of war. Active resistance, as the cop will claim it, turns it into justifying escalation, where the officer can now use that deadly force against you. In fact, as a classic example of this, I put out a video recently where a doctor actually lost his life because an officer was in that situation. So I want you to understand how important it is in this situation. Do not flee the scene and do not escalate the situation, especially when the officer is trying to take your weapon from you. Some of you may be going, Jeff, come on, man. It sounds to me like, you're just going to go along and do whatever the cops say here. I want to give you some important things that I'm trying to cover here. I'm never saying you cannot advocate and stand up for your rights. You should always exercise your rights. You don't have to answer all the police questions. You always have a right to remain silent. You always have a right to an attorney. But it's important to understand the difference between passive non-compliance and active resistance. Exercising your rights, going limp, or protesting what the officers are doing, that is passive non-compliance. That is never a good reason for the officer to tase you or to use deadly force against you. What I'm talking about is getting into an all-out resistance situation where it's an argument and a fight. This will lead to the officers likely being able to justify that use of force against you. Okay, so you've kept calm on severity when an officer claims you did something you didn't do. You also avoid looking like a threat to the officer, and now you didn't run from the scene. All very smart. But what if the officer starts making mistakes and you're doing everything right? Is there a way to turn their mistakes into your legal protection? Factor 4 actually flips the script. Up to now, we've been talking about your behavior during the encounter, what to say, what to do, how to handle it. But this particular factor, it's all about the cops. How did the officer behave leading up to and during the use of force? In the 2015 Supreme Court case of Kingsley versus Hendrickson, the Supreme Court said that you can consider, quote, any effort made by the officer to temper or limit the amount of force. That includes things like, number 1, giving a warning before shooting. Number 2, keeping a safe distance from someone with a weapon. Number 3, clearly identifying themselves as police if they are not in uniform. But here's what's key. Failing to do these things by the police officer, especially when they had the time to do so, makes it look much more like an unreasonable use of force looking at it in hindsight. And this is where Barnes versus Felix comes back in again, because the Supreme Court in that case left open the door for what's known as officer-created jeopardy. These are situations where, because of the actions of the police officer, it created the actual risk, the actual danger the cop claimed he had to shoot in order to stop. The writing's on the wall here with this new decision. If the officer's reckless tactics put both parties in harm's way, then it's back on the officer in determining now, most likely, that was an unreasonable use of force. Now you're talking about more of a civil action and possibly a criminal action against the officer. That brings me to the case of Lombardo versus the city of St. Louis. In Lombardo, a group of officers piled on to a man face down that was handcuffed and struggling to breathe. In this case, the court sent the entire case back, saying that the lower court must consider and focus on whether the police were following their training. If police ignored safer tactics that they'd been trained on, that completely matters. The same holds true with a roadside traffic stop. So how do you, as a gun owner, use Factor 4 in order to protect yourself? You prompt the officer to give clear instructions, and then you get it on the record, whether it's on their body camera, on your dash camera that everyone should have, or even if it's on your cell phone. Say these exact words. Officer, I'm willing to comply. Please let me know what you want me to do. Would you like me to keep it holstered, or would you like to secure the weapon? That's it. You are now putting the burden back on that officer. It is now the officer's responsibility to tell you how they would like you to proceed, and you're capturing it all on camera. If the officer said to keep it holstered, but then he later claims that you refused to hand it over, then the video tells the truth. But if the officer never gives a warning and then uses force, then it's all back on the officer and more likely to be deemed unreasonable. And finally, that leads us to our last and final factor here. In fact, this factor by itself can be the one thing that can help shut down a cop claiming, I had no other choice but to use of force. This can be the one thing that shuts them down, and that is proportionality and viable alternatives. Now, what do we mean when we say proportionality and use of alternatives? Well, essentially what we're saying is, this is where the court asks, did the force used by the police officer match the actual threat at the time? And equally important, were there safer options by the police officer that could have been used that were just simply ignored? This brings me back to the Supreme Court case of Scott versus Harris. In this 2007 case, the police were in a high-speed chase. And I believe I mentioned this a little bit earlier, but they had to use what they called a PIT maneuver, this pit maneuver, where essentially they were forcing that car to lose control and to wreck out. And as deadly as it is, the Supreme Court set a standard in this case. The Supreme Court said, and I quote, officers don't have to pick the absolute least intrusive alternative when you talk about use of force. In other words, cops are not required to be perfect when they use force, but it still must be reasonable in the moment, the court said. But here's the part of this particular case, Scott versus Harris, that protects you and I. And I'm going to give you a quick summary of exactly what the court said here. The court said that if there were safe, obvious alternatives, like backup seconds away, or cover that could have been used, or the option to keep talking to the individual instead of firing upon them, and the officers chose to ignore them, this can be considered by the courts in determining whether the use of force against another gun owner, someone who has a weapon, was reasonable by the police. And of course, now this brings us back to the Barnes case, and all of the things we discussed earlier come into play. I've seen cases where someone was standing still, hands up, just like this, and they still got shot. In those situations, Barnes versus Felix makes it much more likely that police officers will now either be indicted for a felony charge for their behavior in that situation, or you could run into a situation where a civil rights claim could move forward without qualified immunity. But there's always a flip side. If you start making sudden moves, or you start looking like you're about to grab for a weapon, you throw all of that advantage right out the window. Remember, Barnes versus Felix and the 5 rules we just covered right now are all about federal constitutional law and what's protected under the 4th Amendment. But that doesn't mean it gives you a free pass to completely ignore your state's carry laws. Here in Texas, where I'm at, for example, we have constitutional carry for most adults, but you still can't carry in certain locations. Schools, courts, airports, and any businesses with proper signage shown. If you still violate those rules, like I just mentioned, or maybe your individual state rules, Barnes won't save you. You can still be charged under your state statutes. The point I'm making is, it's important to know these federal rules related to the use of force with police officers and know your specific state carry laws. So we've covered all these great factors. We've explained your state's carry laws and how it applies. Now let's put it all together and do a flow chart. Let's do a little decision-making flow chart so that you are ready to protect yourself if things get a little out of hand with a police officer while you're carrying. Here's the situation. You're driving down the road. Police officers pull you over for maybe a ticky-tack traffic violations. They walk up to you and start asking you questions. The first question in your mind should be, am I armed right now? Let's start with no. Let's go ahead and cover very quickly what you should do if you're not armed during a regular interaction. The police officer walks up to your door. You can be polite, that's fine, but you can stand on your constitutional rights. Do not volunteer extra information. Only provide your license and your insurance and registration as required under your state's laws, and then invoke your rights when needed. You can use all factors 1 through 5 that we just covered in Barnes to protect yourself. But obviously, since you're not armed, there's no reason to mention to the officer about any weapon. But what if you are armed? In this situation, particularly if you're in a duty to inform state, when the officer approaches your vehicle, it might be a good idea, definitely in a duty to inform state, to remain calm, keep your hands on the steering wheel the entire time, and inform the officer you are currently carrying. An example of some words you might use, quote, officer, I want to let you know I am licensed and carrying. My firearm's on my right hip. My hands are going to stay right here on the steering wheel. You then wait for instructions from the police officers. Do not move your hands from that steering wheel unless the officer tells you to. If the officer then gives you clear instructions on what to do, follow them precisely during that traffic stop, because you then meet all the requirements of factors 2, 3, and 4 from Barnes. But what if the officer doesn't make it clear what he wants you to do? This part's very critical because I've seen many people make this mistake. It's at this moment you need to make it clear to the officer, Officer, would you like me to maintain holstering my weapon, or would you like to secure it? Whatever you do, don't ever grab for your weapon. You might be thinking you're doing the officer a favor. You may even have an intent of trying to be in compliance with the officer. But the moment you grab for that weapon, the officer is going to draw down on you. This could get deadly, and the officer will be justified in doing so. And in that rare event, the officer continues to ignore you, or maybe he's talking to someone, maybe he's talking back to another patrolman, or actually back at the office trying to find out more about you, running your record. Do not move. If it seems like it's taking a long time, maintain that same position. You got to basically, if this is going to be a game of chicken where the officer's waiting on you, the moment you start to move in any fashion whatsoever, the officer may claim you're now a threat. And finally, when the stop ends, if they disarmed you and they've gotten through the entire traffic stop, it's important to ask, officer, am I free to leave? And may I retrieve my weapon? Take it back carefully and only reholster after the police officers have cleared the scene. By following exactly what we just covered here, the U.S. Supreme Court in Barnes made it crystal clear you would have been deemed to act reasonable. And if the officer still wanted to have an agenda and take it out on you, now any use of force by that officer would be deemed most likely unreasonable. And finally, I want to ask you a question. Would a small card with your rights and these 5 factors printed on it be of help to you? On one side, it might show your basic rights during a traffic stop. I do not consent to searches. I wish to remain silent. I request an attorney. On the other side, it would be Barnes and these 5 factors written in plain English so no officer could ever justify use of force against you again. If you would find this helpful, please let me know down in the comments. I'm considering putting this together for all of my members on this channel. You might never hand it to an officer, but in a high stress moment, you could look down and see the checklist and it might center you, just like a pilot uses a checklist. Pilots have flown thousands of times, but they have the small little checklist card that they look at over and over again to center them and remind them so they don't miss anything under stress. So now that we've covered the 5 factors in Barnes versus Felix, what happens if a cop, instead of pulling you over, now shows up at your front door and demands to see your guns? Check out this next video where I break down 5 tips whenever cops want to see your guns. See you over there.